Good morning, everyone. My name is Mike Conroy. I'm the Employee Benefits Practice Leader here at Walsh Duffield. Want to thank you for joining us today's webinar. The title of the webinar is Fiduciary Compliance and Key Provisions of the Consolidated Appropriations Act, the CAA. Today, you'll hear from Michael Flanagan. He is a partner and Employee Benefits Practice Leader at Hodgson Russ. Just so you know, this webinar is the first of our summer school series, where we'll be touching on several topics weekly that impact HR and employee benefits. If you haven't checked on the rest of the lineup, certainly be sure to go to our webpage, walshduffield.com/summer school. There we give a description of the presentations, and then we also offer the link to register. So just a couple of housekeeping items before I turn it over to Mike. Today's webinar is being recorded, and we will share the link with you as well as the presentation slides. This presentation is approved for 1 SHRM professional development credit, 1 business recertification credit hour through HRCI. We'll email those codes out after the presentation to the attendees live only after the webinar. So during the presentation, during Mike's presentation, we invite you to use the Q&A box on your screen. If you have any questions at any point during the presentation, please enter in the Q&A box. We are going to hold it for the discussion portion at the end of the event. So with that, I'm happy to introduce today's presenter. For more than 15 years, Mike has concentrated his practice in employee benefits law with a focus on welfare benefits. He's proficient in matters regarding the ACA, COBRA, ERISA, HIPAA, and now, we've got a new one, the CAA to the alphabet soup, the Consolidated Appropriations Act, and the numerous requirements that will impact employer-sponsored group health plans. He'll also go over actions you can take working with your consultant to reduce fiduciary risks as it relates to CAA as well. So thank you again for attending. And at this time, I'm going to hand the floor over to Mike, and he'll start today's presentation. Mike, it's all yours. Thank you very much.
Terrific. Well, Michael, thank you for that introduction. And thank you all for joining us today to talk about, these issues that, summer school is never something that people, kind of highlight, but hopefully you'll find a lot of value here. That's what this is about, is, trying to focus you on things that are important. And today, we're going to be talking about welfare benefit, fiduciary compliance issues. And, the fiduciary compliance for ERISA plans is not something new. ERISA has been around now for about 50 years, but we've been accustomed to really talking about fiduciary compliance in the context of retirement plans, making sure we've got investment committee meetings and those, decisions well documented. Concern perhaps about, from the plaintiff's bar regarding excessive fee or stock drop litigation. These sorts of things have, in the last 20 years at least, have been the focus of, fiduciary compliance. But we've been less focused on welfare benefit fiduciary compliance issues. And excuse me, that is about to change. I think, really the issue is why now? So this is fiduciary concerns have been, primarily retirement plan issues. Why are they now welfare benefit issues? And I really look to 2 things. One has been sort of an issue that's been in play for some time now, which is increased cost. Follow the money. And in terms of particularly medical plans, the costs associated with providing those benefits for operating those plans has gone up, skyrocketed in the last few decades. And now we're really, facing a situation where it's a significant portion of our employee benefit budget is making sure that these benefits are provided in the most cost-effective manner that we can. I guess, gosh, now it's been about 12 years since the Affordable Care Act went into place, but the Affordable Care Act really focused on who was paying the cost. It really didn't do as much to sort of bend that cost curve. The CAA now, I guess, is perhaps going to be the issue that addresses the overall cost. So one issue is the terrific expense associated with these plans. The second issue is the access to information. And really that's where the CAA comes in, which is, this is a provision, this is a law that went into effect the very end of 2020. There are numerous provisions. There are about 15 provisions that affect health plans. And if you were to sort of look for a common thread throughout all of these provisions, it would be greater access to information, both for plan administrators, fiduciaries, but also for plan participants. So previously, costs associated with these welfare benefits was lower, and there was no access to information. It was basically take it or leave it. Now there's a much more expensive benefit, and the access to information is much greater. So I think those two issues are really what's driving this push towards more diligence on the fiduciary compliance end of things. So I guess with that, let's talk about, maybe a good place to start is when we're talking about fiduciary compliance, is trying to figure out, well, who is a fiduciary? And under ERISA, we're really talking about two main types of fiduciaries. First, you have the named fiduciary. And this would be, for example, like a plan administrator, maybe a benefits committee member, a board of directors. These are folks that are fiduciaries based on their role. Typically, they're named in the plan document as fiduciaries as well. Those ones are pretty easy to identify. Less easy to identify are the functional fiduciaries. These are folks that are fiduciaries because of their actions. So if a person exercises control or has authority of plan management or administration of plan assets, that person is a fiduciary. Now, this can be a little bit tricky because there is no formal authorization required to assign somebody a fiduciary role. That, again, this could be done by their action. A person doesn't even need to know. They don't have to be aware of the fact that they are a fiduciary. So this is an issue where, for purposes of compliance, you're going to want to evaluate who is exercising control over this plan and make sure that we've identified those people, have the right structures in place so that the actions that they're undertaking are consistent with their fiduciary role. One of the things, and I have it here on the slide, is that fiduciaries have to conform their behavior to certain standards of care. I'll talk about those in a moment, but there could be personal liability for breaching those standards. So again, identifying who is a fiduciary, making sure that those individuals are aware of their status, that they know the appropriate ways in which to act. That's a great starting point for compliance. Now, I guess, one of the things that we'll talk about here are the fiduciary duties, but maybe just another note on identifying a fiduciary. That could also include, for example, a service provider. And an example that I use for a service provider that would be a fiduciary would be a claims administrator, or individual that would adjudicate claims on behalf of, for example, a medical plan. Though that individual would be a fiduciary for that purpose. Even if there is a services agreement that disclaims fiduciary status, again, the action of having discretion to make a determination as to whether or not a benefit is medically necessary, for example, or that would be a fiduciary action, and therefore in that case, service provider would be a fiduciary for that purpose. And maybe just one last point on the identification of fiduciaries has to do with the fact that although entities can delegate authority and fiduciary responsibility, those entities would still retain some degree of fiduciary status. So they would be co-fiduciaries. And an example here would be a board of directors would be, perhaps the starting point for their, for the fiduciary obligation. They are the sponsors of the plan. They are responsible for its administration. Now, those individuals could delegate the authority for the management of that plan to benefits committee, for example. But that board would still be obligated to monitor and supervise that benefits committee to make sure that they're, carrying out their fiduciary responsibilities appropriately. So again, it's in the identification of who is a fiduciary. Delegation is a big part of that. But even if you've delegated authority, you still retain the obligation to oversee and make sure that you are, monitoring the activities of those you've delegated authority to. So with that, now talking about the fiduciary duties, there are 4. I've only listed 3 here. The duty of loyalty, prudence, following the terms of the plan, and also there's a requirement for diversifying investments. That's really not applicable here in the welfare benefit context, so I did not include that. But these duties, when we're talking about compliance, when we start with the duty of loyalty, this is really about an approach or a mindset. So when you act as a fiduciary, you must act solely in the best interest of plan participants. Often, those of us who are working, with plans have to wear, and this is where you always have multiple hats, is that there can be different roles that you serve for a company. You may be, in HR, you may be required in some circumstances to act on behalf of the company. But when you are acting as a fiduciary, you must be acting with the best interest of plan participants. So here, the focus really is on making sure that the expenses are reasonable and that you are, providing information that is accurate and timely. And if you serve, for example, on a benefits committee, the discussions of that committee should be framed around what is best for participants. Again, it is that duty of loyalty. The second duty here that we'll talk about really in the final one for today's discussion is really the duty of prudence. And this has, 2 components. I would say critically, the things to focus on here are procedure and process for decision making. So, much like in the retirement plan context, where it doesn't always matter that the investments are in the right vehicle. What matters is that you've taken a prudent and appropriate approach to making that selection. That same sort of process in the welfare side also exists. That is, that you can show evidence that you are engaged in a process for decision making that, again, is consistent with the duty of loyalty in the sense that it is in the best interest of plan participants. So, for example, having that proper delegation of authority, if you've got a charter or something that transfers authority from the board to a committee, make sure that, we've got that in writing, make sure that we've identified that, as well as if the committee is delegating authority, for example, to a claims administrator, make sure that we have sort of those steps in writing, that we've got them sort of easily identified, and we know who is responsible for what. So which duties are retained by which entity. That is an important part of this procedure. And then in addition, I would say for these due diligence purposes, focus on the substance of, once you have that structure in place, focusing on the substance, which would be, compliance concerns, disclosure, the regular disclosure issues that we've, dealt with benefits, SPDs, SBCs, 5500s, all of that, still matters, and it would still be a part of the subject for discussion for these committees. But also taking a look at, RFPs, or making sure that the committee is utilizing talent and services that are at a reasonable cost. And the way that you can demonstrate that is by, again, engaging in these discussions, in doing RFPs, and I think importantly, documenting that process as well. So it's not only a matter of doing it, but also keeping receipts. So just, a few items here in terms of actions to reduce fiduciary risk. Number one, identify who your fiduciaries are. And I would say also, part of that is, part of the identifying who your fiduciaries are is how that authority has been delegated. If it's been delegated, for example, to a benefits committee, hold regular meetings, document your actions, and keep a record of that. That is going to be important if there should ever be a claim that there has been a fiduciary breach. You want to show that you have, been attentive to these issues, that fiduciary compliance has been something that is important and you've invested in, and you can show that by, meeting minutes, again, documenting RFPs, things like that. And then 3 and 4 on this list are, focused on staying up to date on fiduciary education and reviewing your process, trying to determine, are we doing the things that we need to do? Are there areas that we need to tighten up? And that should be an ongoing exercise. So now I would say, switching gears a little bit, let's talk about the Consolidated Appropriations Act, the CAA, that are currently in effect. So again, this, the first issue is really talking about, let's get our fiduciary compliance house in order. And, now we're talking about one of the reasons why we need to do that, which is because we have this new law, which really opens the floodgate to a lot of information. And, I think it's, who is it? Stan Lee from, the Spider-Man, that says, with great power comes great responsibility. It's sort of that same issue with information. So previously, where we had, very little information, we had very little responsibility. Now, with much more information available, it ups our obligation in terms of our fiduciary role. And, I'm going to talk through a number of these CAA provisions that are in effect currently. And again, a common thread throughout all of them is this increased access to information. This first item that I'm going to touch on is the mental health parity reporting. So just taking a step back, mental health parity, this is not a new law. It's the acronym is I think worse than the the full title, but the full title is Mental Health Parity and Addiction Equity Act, or MAPIA. That went into effect in 2008, but enforcement has been, pretty lax around this issue. Well, beginning in February 10, 2021, plans have been required to produce an analysis of certain non-quantitative treatment limitations that may apply to mental health or substance abuse disorder for the benefits that are provided. So, they're sort of getting into the weeds a little bit. The NQTLs, or non-quantitative treatment limitations, these are things like requiring prior authorization for inpatient service, or sometimes they have what are called fail first policies or step therapy for different types of drugs. And these types of limitations, if the plan has these types of limitations for mental health or substance abuse disorders, then the plan has to be able to produce an analysis to see how that compares to any similar limitations that are placed on medical surgical benefits. From a practical perspective, and you'll see this as also a common theme throughout the things I'm going to talk about, employers really are not well positioned to do this analysis themselves. This is something that, there really has to be reliance on the insurer or the claims administrator. They're going to know the particular details about these types of limitations. From a fiduciary standpoint, even though this is not going to be an issue where you are, drafting perhaps this analysis yourself, although I think the Department of Labor has a self-compliance tool. You can peruse that, but I think for practical purposes, the way that you comply with this provision is you engage with your insurer or claims administrator to determine, first of all, do these types of limitations exist currently? And if they do, how do we go about preparing an analysis, as required under this type of provision? All right. The next item under the CAA that I want to talk about is a prohibition on gag clauses. So oftentimes in services agreements, at least used to be the case, there would be language that would restrict the flow of certain types of information. Now, to be clear, there still will be restrictions on information. Information is gold, right? And it's becoming more and more valuable, not only to plan participants and plan administrators, but also folks that serve the plan, like claims administrators. And so there's, this is often in negotiating these services agreements, the flow of information is often a, what is protected and what isn't protected is a hotly contested item. Well, now with this new provision under the CAA, there is a requirement that these services agreements cannot contain gag clauses, that is, provisions that would limit the flow of certain types of information. It's not universal. I mean, there still are ways that providers can protect, certain confidential information, proprietary information, things like that. But it has to be carefully drafted in a way that complies now also with these gag clauses. And again, a services agreement that would contain a gag clause could be problematic as a fiduciary. This is a law. It is intended to benefit plan administrators and participants. Having a gag clause in a services agreement could be problematic for fiduciary compliance. All right, so the next item is broker and consultant transparency. So under this, brokers and consultants, I believe it's who are reasonably expected to charge more than $1,000. So it's pretty broad. Must disclose services that are to be performed and how they will be compensated. And this is both, compensated directly and indirectly. And this is meant to inform fiduciaries, again, the plan fiduciary, whether the compensation is reasonable for the services being provided. Up to this point, it's been, plan administrators know what their, what a particular fee is, but they may not be aware of commissions or other compensation that would be going to brokers and consultants. Now this must be disclosed. And I think as indicated here on the second bullet, one of the issues that is important to note here is that it's not just a requirement on the broker consultant. If you engage with services with a broker consultant without getting this information, it would be considered a prohibited transaction. And that's, a significant level of concern for a fiduciary. So, this is going to be something that, again, is in effect now for contracts that are, being renewed or going into effect. And, that information should be, requested. It should be a requirement prior to entering into an agreement. And again, is part of that sort of evaluation process. It gives the fiduciary the tools to know whether or not a particular, service provider is, if that amount that they're receiving for those services are reasonable. All right, so I want to just briefly here talk through a number of additional items regarding the transfer of information. These are, primarily associated with participants. And again, these are not going to be issues that a fiduciary, plan administrator is going to undertake themselves. These issues are going to be baked into the plan, and you're going to rely on your, claims administrator, your insurer, to make sure that these issues are actually in effect. But the continuity of care, that should be, it's a sort of a narrow situation where if a participant is receiving care from an in-network provider, and then that changes, so now they are out of network, that they would continue to receive care at the in-network cost. Similarly, there are certain provisions protecting participants for emergencies, so air ambulances, also for individuals who are are at a in-network hospital, but a service provider is out of network. So the example here is, you may be at an in-network hospital, but the anesthesiologist may be an out-of-network provider, that has to be disclosed, or it will be paid at in-network rates. The insurance card information, this is something that you likely have seen, providing participants with information where they can go to get access to directories of, who is in network, who is out of network. And then finally, an independent dispute resolution process. This would be where there would be, if there were a situation where there was surprise billing. So somebody is out of, gets service provided by an out of network provider. The independent dispute resolution process would be a way for that dispute over the cost, what a participant or plan should pay, can be resolved. And again, all of these items are not going to be things for, HR folks to be handling independently. These are things that as a fiduciary, you should engage those service providers, again, the insurers or claims administrators, to determine, hey, where do we stand on these? Is this currently in place? If not, what are the steps needed to make sure that we are in compliance, and how quickly can we get there? One last item that I wanted to point to here is something that is not yet effective. It will become effective for plan years beginning on or after July 1 of this year, but it is, again, affecting the flow of information, and this is the flow of information to participants about 3 types of cost sharing, for healthcare providers. And this would be information put up on a website, again, gaining access to information that previously was not available. And I think, if I were to sort of look at all of these provisions again from sort of top to bottom, the issue is greater access to information. And the reasoning is, I believe, that the more information there is out there, the more sort of cost pressure there will be to keep those costs in line, so that there's not this sort of exaggerated growth in cost. But in terms of takeaway for you as a HR professional, I would say, first of all, to recognize that fiduciary compliance for welfare benefit plans, the game is changing. There's a greater need for much more rigor around the welfare benefit fiduciary compliance, if that is the formation of a committee, if you don't already have one. If you have a committee already, make sure that you've got the proper delegation of authority in writing, be by either plan document or a charter. Hold regular meetings. I would say review plan operations and document those meetings. All of that is evidence that not only are you focused on the plan participants, again, that duty of loyalty, but you're also undertaking that duty of prudence, where you are putting those structures in place to maintain your compliance. And with a lot of these CAA provisions, much of that is going to be handled by other folks. It's going to be handled by claims administrators or other service providers. But you, as a fiduciary, will still have the duty to monitor and make sure that those duties are being performed at a reasonable cost. So I think with that, hopefully I've stayed within the boundaries of my time limit here, but I'll be happy to answer questions that you might have.
Mike, thank you so much. This is definitely a very important topic and very complex, and you've done a great job really breaking this down and going through the various topics. I do have several questions that have been submitted by the audience. So just as a reminder, if you have a question that you would like to discuss, you can go ahead and enter it in the bottom in that Q&A section. I will try to keep an eye on it, but I'm going to go through some of the ones that I've already received. So one of the first questions is, does the CAA and no surprises provisions apply to Medicare Advantage and Medicare Part D?
Oh, excellent question. I don't have I don't know the answer to that question. It would be likely that some of the provision, I would imagine that some of the provisions would apply. Again, this is a multifaceted set of laws. So, we've got dozens of provisions, and it may be that it is likely, in fact, that some of the provisions will affect certain types of benefits, but not all. So I can't speak with certainty, as to those particular issues, but I would say that it is likely that, there will be some effect, but the extent, I just don't know.
Okay. So talking specifically on funding arrangement, are there additional concerns for self-funded medical plans as it relates to CAA versus those that are fully insured?
Yes. So, I mean, as is often the case with fully insured plans, there is a greater responsibility that goes to, the plan fiduciaries for the self-funded plans. And, just to sort of walk through, this extends, even well beyond the CAA, but, in looking at, a number of these provisions like the, let's see, the dispute resolution, just to pick one, there would be a situation where, there would be a requirement, the requirement is on the plan, and you would be, as plan administrator or plan fiduciary, delegating some authority to a plan administrator, such as a claims administrator, to adjudicate certain claims. Now, part of that you would want to renegotiate or add, hopefully, services for that claims administrator to take on those additional responsibilities. So, I think it is often these provisions are drafted in a way that the onus is really on the plan administrator, the plan itself, and is often the case. Those self-funded plans, the level of compliance falls more squarely on their shoulders to get out, and really benefits them to get out ahead of the issue with those service providers to make sure that those issues are being addressed.
Thank you. So similar, this next question, will this increase the pressure on employers to hold carriers and TPAs accountable to provide the required claims information and reimbursement transparency that's required under CAA? And if the carriers and TPAs are unwilling to provide the required information, is it in the client's best interest to identify partners that they can work with to meet the requirements? So I guess,
Absolutely. Yeah. No, I think that's clearly the intent of, these various provisions. If you look at them, if you take a step back and take a look at them from the 30,000-foot level, you can see that that's exactly what the legislative intent is, which is to say, first of all, as a plan fiduciary, you have to be engaged in the decision-making process. And so through these various provisions, now you have additional tools. You'll have more information to, upon which to make that determination. And I should be clear here that it's not a situation where the lowest cost always wins. It's not always simply a matter of, we're going to line up 3 service providers and figure out who has the lowest cost and that they're going to be the winner all the time. It should really be an evaluation based on value. And so you may choose a provider that may be, not the least expensive, but if it does, to the questioner's point, if they are able to show that they are, addressing all of the various compliance concerns, that's going to be a greater value than, somebody who comes in at a lower cost, but, isn't meeting all the necessary standards.
thank you. So talking specifically about the public disclosure tool, the question is relative to the machine readable files, when that goes into effect after July 1st, is it that the responsibility of the company to post that, or is it the carrier's responsibility to post that? And then will the answer differ depending on if it's a fully insured or a self-funded plan?
Well, I would start with the idea that it is going to be your responsibility as the operator of the plan. But from a practical standpoint, where I would recommend is, engaging the insurer, the claims administrator, as the case may be, to, walk through this issue, because, regardless of who is, from a legal standpoint, who's required to do this, the machine readable files, this is not something that an employer is going to be able to put together themselves. This must come from the insurer. It must come from the claims administrator. And so really, to solve this problem from the most, pragmatic, practical way is engaging them in the discussion. What steps do we need to take to make this happen? And so in really, that is, I think, the most productive way to address that issue, which is, the information will come from insurers, will come from the claims administrator. Get them on the phone. Let's work through a plan to get that up and running.
Thank you. We've talked a little bit about different funding arrangements and the impacts on CAA, but we have a question on, does the size of the employer's workforce have an impact on CAA?
No. So these are going to be issues that are going to be applicable. Again, it's so unlike, for example, the Affordable Care Act, where we had that 50 full-time employee, including full-time equivalent threshold before we worry about the employer shared responsibility provisions. These issues are going to be applicable to these plans, and the fiduciary compliance piece, again, is not conditioned on the size of the plan, the number of participants. These are responsibilities and roles that you undertake with with sponsoring these benefits.
Okay, well, Ness, can you reiterate the requirements of an employer to have an internal committee relative to this?
Sure. So I would say, there's not a requirement to have a committee. I would say it would be, I would put it in the category of best practice, where, what you would have typically is, for example, a medical plan that would identify the company as the plan administrator. What practically that means is that the board of directors of that company are all the fiduciaries of the plan. Now, it is, in my experience, uncommon for that board of directors to really have that much day-to-day interaction with the plan. So as a way to better organize the authority and responsibility associated with that plan, it would make better sense, in my opinion, to have the board, through a charter, delegate authority to a committee, sort of identifying what specific duties that committee will undertake and what duties and responsibilities will be retained by the board, and then have that committee be empowered to make those decisions. They're likely already making those decisions, things like signing contracts and acting in that capacity. But this will be a formal delegation that recognizes it, and also provides certain protections. They'll oftentimes a charter will include some indemnification language that will protect these individuals that are serving on the committee. And again, without those sort of formal structures, those individuals still may be deemed fiduciaries based on their function, because we've got the role, the named fiduciaries, but then we also have people that are acting in a fiduciary capacity, and those actions will put them in that position. And we want to make sure that, first of all, everybody knows what role they're in, make sure that they're acting accordingly, and to the extent that we can provide some protections, we should do that as well.
Thank you. Mike, thank you so much for your time and for going through this topic. As I mentioned, a very important, complex topic. I'm going to hand it over to Mike Conroy to wrap this up and talk a little bit about our next upcoming topic in our summer school series. Mike, I think you're on mute. If you're talking, you're definitely on mute.
Okay. I was on mute, but I'm back. So thank you very much, Kim. Thank you everyone who joined for today's webinar. It's interesting being on the carrier side for almost 20 years. I can tell you, I'm excited for the CAA because the lack of transparency in this industry has really led to rising costs. The CAA arrived with a lot less fanfare than the ACA, but I do believe the impact it can have on this industry long-term can be very positive for the consumers and for employers. So I'm excited to see the changes. So anyways, as I mentioned earlier, to register for next week's webinar, view this on walshduffield.com/summer school. Certainly check out the topics and register for the events that you'd like to attend. If you do have any additional questions or would like to connect directly with the Walsh Duffield team, please feel free to reach out directly to us on the contact information provided in the chat box. So thank you again for joining us today, and hope you have a great day.